the moment I still most enjoyed, although in the moment it was quite terrifying, was just was going to Hong Kong on the Snowden stuff, when Snowden was in Hong Kong, and the whole thing just blew up. And you're there as a lawyer. Lawyers are there sitting at desks with quill pens, writing things, and I'm walking round some park with a journalist with no electronic devices telling me what's been going on.
That was the voice of Gill Phillips, former Director of Editorial Legal Services for Guardian News and Media Limited. I'm Sarah Cole, founder of Cole Forums, a high-trust network for CEOs, general counsel and senior leaders. I'm the host of Insights from the Coalface, and through my podcast, private dinners and curated events, I bring together extraordinary leaders for honest, no-filter conversations that go far beyond the boardroom. Each episode features global experts, from neuroscientists and journalists to CEOs and ethicists, sharing bold lessons and practical strategies. We explore the science of trust and motivation, the power of communication, the role of ethical leadership, and how to balance high-stakes careers with a fulfilling life. Cole Forums creates the framework. You and your peers make the magic happen. Gill Phillips was the Director of Editorial Legal Services for Guardian News and Media Limited, publishers of The Guardian and Observer newspapers, and TheGuardian.com, from 2009 to 2023. She was educated at Selwyn College, Cambridge, and qualified as a solicitor in 1984 with the firm Coward, now Clifford Chance. She joined the BBC as an in-house lawyer in 1987, later working for News Group newspapers and Times newspapers. She moved to GNN in May 2009 and has advised on phone hacking, Wikileaks, the Leveson inquiry, the NSA leaks from Edward Snowden, and more recently the Panama Papers, the Pegasus Project and the Uber files. She sat as a part-time employment tribunal judge until December 2024 and is a co-author of McNay's Essential Law for Journalists and the University of Law Employment Law Handbook. Since retiring, she has joined, reviewed and cleared as an editorial legal consultant and helps teach law on the City of St. George Journalism MA. She is a non-resident fellow of the Centre for Media, Data and Society at the Central European University School of Public Policy and holds an honorary law doctorate from London South Bank University. Gill Phillips, thank you for joining us. How are you?
I'm good, thank you. It's a lovely sunny day.
Yeah, I know. And usually in Wales, also sunny. And I probably should make a note on my calendar because it never happens yet. So, Gill, thank you so much for coming, first of all, to speak to us. I mean, I was trying to figure this out earlier, as I always do with my guests. And I think we've known each other hideously since 2009. So a long journey for you. And you would have just joined The Guardian then. What I really like to do, if you don't mind, is just go right back, way before then. I mean, I knew you were with Clifford Chance initially. It would be absolutely fab if you could talk to us a little bit about how you even got into the law. Never mind anything else.
No, well, never mind anything else. I mean, actually, I sort of, I quite enjoy talking about this bit in the sense that I started off reading history at university and I didn't know anything about law at all. It had never crossed my path in any shape at school or anywhere. And then, you get to university and you meet people who are doing different courses. And so suddenly your world, well, certainly in those days, expands as to possibilities. But, I did my history part ones. That's 2 years of history, which I did love it. I still love it. And there's some crossover actually, between that and where I've ended up in terms of facts and research and, those sort of things. But by the end of my second year, I was sort of getting a bit nervous about what you did with a history degree, because people went into things like accounting and I can't add up. I still can't add up. I'm definitely a fingers person. So that, that didn't really appeal to me at all, or teaching, which I just didn't really see myself doing. So I sort of started just having a look around about what else I could do. And then I realized I could change courses and do a law degree. So I shifted courses. I mean, this is back in the I would call them the dark ages, but the light ages where, we were paid in terms, well, we didn't have to pay in terms of fees and things like that. So you had a bit more flexibility around your time. So I did 2 years instead of 1 year. So I ended up doing 4 years, 2 years of the law degree squeezed into that, and came out with a law degree.
That must have been tough though, 2 years ramming it
Well,
in.
it wasn't. It wasn't. I mean, you still had to do the core, the six core areas. You had a little bit of choice around the edges about other topics. And I did a long vac term. I think 3 or 4 weeks in the summer as an introduction. But actually, it was fun. I loved it. Um, Even though it was, completely different from history, where history we had maybe one lecture a week or two. You didn't have to go to them. You did a couple of essays and then you talked about them. Law, you would have 3 or 4 lectures a day that you really needed to go to, and 2 or 3 tutorials a week. So it was a very different way of working. But yeah, it worked for me, and I liked the fact that there was a career progression at the end of it, although I was also completely ignorant. I didn't know the difference between solicitors and barristers, or civil law or criminal law. And I think it's really interesting. You can go through a whole academic course and not understand any of those things. But, that is the reality.
So how did you land in Clifford Chance then? Because that's hardly somewhere where you might be confused about what the law is when you land there.
No, well, I guess I was fortunate in that I went to Cambridge. So, I mean, I say fortunate. I mean, looking back, yes, I was fortunate, and I had a fantastic client in Cambridge, and it was great. But most of the people who did law at Cambridge looked towards going to the city, and so I was a bit lemming-like in that sense. And I just did what others did and applied to city law firms. And I had a decent degree, I had a decent background, and I got offered a place at what was then Coward Chance, that became Clifford Chance down the line. But again, enormous amount of ignorance on my part about city law firms. I mean, I did apply to some small criminal practices, the complete opposite. But one, they didn't offer me jobs, which may be just a reflection on my ignorance, which they could see. And two, it was so different. They were all in sort of little back streets and up creaky old stairs with dodgy carpets. And then you would, even in those days, the city law firms, which when I started at Coward Chance, I think there were 20 partners. That was considered big. But they still had quite swanky offices and big reception areas. So yeah, so it was, very different. And but it didn't take me long to realize really it was not the place for me.
Having loved the law though up until that point, what was it about that environment that you thought, right, this isn't for me, I need to be doing something else?
Oh God, all sorts of things. I mean, there were some really nice people, and I made some really good, long-lasting friends that, people I still know today. And it was full of some very clever people, but it was also full of people who were interested in making money and money and money and banking and commerce. And, none of that rang my bell at all. And not that you necessarily know that until you get there. I did a seat in litigation, which is where I qualified. And obviously litigation, you can litigate anything. The basic tools and skills of a litigator are multi-purpose in that sense. But, litigating over great big banking deals where someone's arguing about millions of pounds, and it was not for me. Definitely not. So, I did about 3 years PQE, and during that time I was looking for something else. I didn't know what. And again, I think that's one of the things I would say, Sarah, is, some people know very, very clearly, don't they, what they want, where they're going to go, how they're going to get there. I had no idea about any of that. So part of my journey was just exploring things. And you'd go for an interview and you'd go, oh God, this is fantastic. But they wouldn't offer it to you because you didn't have the qualifications. Or you'd go, oh God, this is even worse than what I'm doing now. So I'll stay where I am for a little bit longer and see what comes along. And eventually a job advert came along. It must have been in the Law Society Gazette for a solicitor at the BBC. And I thought, oh, now that sounds, again, what did I know about the skill set? But I thought that sounds much more interesting. And I went along and met them, and the rest really is history, because that's what got me, one, in-house, and two, doing media.
I've heard you speak about this before, though, and I remember what struck me about it was you said there was no such thing really as media law as such. It was more sort of specialist litigation, I guess. Talk to us a little bit about that.
Yeah, I mean, that's definitely the case. I mean, I went in as a litigator to do defamation, as a specialist litigator, because back in those days, they didn't have specialist litigators. They had lawyers who were doing defamation, but not not from the litigation perspective. So that's the skill set that I bought, and I think I'd done one bit of defamation in private practice before, but and then you're just there on the job. We were in offices just behind John Lewis in Oxford Street. Very nice. It was very gentle. There was a tea lady with a tea trolley, came round twice a day. I had my own office, old-fashioned office with a wooden desk and stuff. Um, and I mean, also personally, for me, you didn't have to wear suits and look smart and pretend to be, uh, mutton dressed as lamb, or whatever my mother might have said. I didn't have to stuff myself into something I really didn't want to stuff myself into. So it was more relaxed, and that was much more me, I realized.
How, by the way, you're talking about it, you sort of start to find your stride, I guess, maybe at this point.
Yeah, and I mean, I think it's a sort of message that might come out in other things that we talk about, but finding out who you are, what you want, where you're comfortable, where your strengths work, and making decisions around that, I think is quite important. And I don't know that enough people just take that time. I mean, because you don't have to, you just find yourself. But I do think it's a good thing to do at some point. And I think people who move jobs or whatever maybe do that, at least subconsciously.
Yeah, I think that's probably right. And it was interesting hearing you talk about your career because I did a politics degree and then transitioned to law. So, and actually, I'm grateful now. All at the time, I was quite frustrated. I think it sort of gave me just a little bit of a different route, a different perspective.
I agree. And I think, that's why I think, again, people were a bit sniffy back in the day if you switched in some way, or you did the conversion course, as it was called then. Whereas now I think they look at people who come to the law with a different first degree as exactly what you said, being able to bring something that is different, a different perspective on things, a different way of looking at things, and appreciating the value of that.
And you moved really, I guess, quite a lot for those days, right? Because you were BBC and then you were Times Group, I believe, and then you ended up in The Guardian. So what were the catalysts for those moves?
I mean, yeah, it is. You're right. I mean, my father didn't ever move jobs until he took retirement, and then so he did 30 years or so working for the same company. And I think I was just part of that generation where there was more flexibility and more movement, and you didn't look at jobs as being jobs for life anyway. But yeah, I mean, I did 10 years at the Beeb, and they were just that John Burt had come in, and there was a big reorganization and restructuring going on of the legal department as well as other things, and they wanted us to shift around and make decisions. I mean, we used to do a bit of everything. We used to do pre-pub, strategy, policy, as well as some litigation. And they started wanting to sort of make you do particular bits. So you had to go into one department. And I actually liked doing it all. And yeah, so there was definitely a sense of unease and change. And yeah, I got offered a job at the News of the World, paid more, looked like it was the same sort of work. So I I hopped over to that. And I mean, much as they were really nice people, I realized I was a bit of a snob about things. You know, legally, well, legaling a 500-word story for the Sun or the News of the World is very, very different from legaling, Horizon or Watchdog or whatever or Panorama or Newsnight for the BBC. And it's the same skills, absolutely the same skills, but, very, very different process. And yeah, I just sort of thought, again, it wasn't quite right for me. And also at that point in time, we touched on this in our pre-chat, but I was just coming out as a lesbian, and working for a tabloid at that time just was really uncomfortable. I mean, their front pages were full of lesbian and gay vicars and rugby players, and in a not very nice way. So I just sort of felt uncomfortable personally, and I just felt the need to opt out for a bit.
And I think it was super courageous, really, of you to be so open about your sexuality in that environment when you look back at it. I mean, I know you play it down, but on the outside looking in, I can remember thinking that. And yeah, I can see why The Guardian would have been, it's certainly in those days, if, I think now is a way more liberal paper than most of the other broadsheets as they were then. So,
Yeah, I mean, I think, as I said, individually, the people were were no different, and I don't think they would ever have personally attacked you, but personally, my values were feeling a little challenged. And when I was at the Sun and the News World, I wasn't out, so I was leading a little bit of a double life. I was married, I had kids. It just all felt not quite right. And I mean, the other thing that people have said to me is, "Well, you work for Rupert Murdoch." I wasn't so bothered about that, to be honest. You did your job. You did what you did in that sense. But my left wing friends were forever chucking that at me. But it wasn't really that. It was my personal circumstances and just needing to sort of go somewhere a little quieter and more retiring, which I did. I went off to the College of Law for a bit, taught there, and then went back to the Times.
I mean, just listening to you talk about values and your own personal values, I mean, that's very fashionable now, but I do get a sense, and I certainly did when we first met, that that's always been massively important to you.
Yeah, it has. I mean, I do think that it's important, as I said, that you work out who you are, and where your boundaries are and where your limits are. And I mean, some people are going to be very, very happy putting themselves into challenging positions and sort of fighting against the flow, or going into a particular environment, and not being uncomfortable about it. I realized I did need my sort of work environment to be something that I believed in. And working for, particularly obviously, the Beeb and the Guardian down the line, their output, the way they approached things, also touched my ethical buttons and boundaries. They both tried, and I'm not saying that others don't, but they made a conscious effort to do things ethically. And of course, they didn't always get it right, and to do things, you know, in a fair way and represent things fairly. And that's something I've always felt quite strongly about.
You've touched on maybe not always getting it right. What about personally? Do you think there's anything that you reflect back on that you wish you'd done differently?
Do you know, I no is the honest answer to that. In an ideal world, you would just get to straight to where you end up if you're feeling comfortable there. But I looking back, yeah, you have to go down some blind alleys and other things. Well, most of us do, I think, before you find what works for you. And not everybody ever finds that. So I mean, the only thing I've sort of got any regrets about, and it's not about approaching things differently, is that as you know, I was also a employment tribunal judge, and for a while I did fancy sort of seeing whether I could get into the sort of high court, district court judging, and I never, and I realised I didn't one, I don't know that I've got the necessary attributes. But two, you need to, if you're going to do something like that, you've got to really go for it. And I didn't really go for it. 100%. I tried to do it, you know, of an evening when you were trying to do other things. And I think maybe, having a proper go at that would have been something that I would have liked. I like judging, I mean, I'm quite a consensual person. So,
I can imagine you're really good, actually. Very good.
well, rather than advocating, one side against the other, seeing both sides and trying to find where the fairness or the law sits, I quite enjoy that.
Arguably, though, you were quite busy with the day job at the time. I mean, I was thinking about this before we spoke, and I think that you must have been involved more than anyone else in terms of navigating the complexity of a legal landscape with more major journalistic endeavors than anyone else that I've come across in my career, which is, some 30 years. And look, you can arguably say that's a bit of luck, but it's probably the institution that you decided to work for as well, and how they approach, I suppose, breaking news around big issues. But let's just canter through those, because there's no way we could do a podcast or three on each of them, I'm sure. But I was thinking maybe it would be nice to hear some of your specific memories around, I don't know, the phone hacking scandals first, maybe, and then we could talk about the other big ones.
Yeah, I mean, again, I would say I was lucky. I got to The Guardian at a time when Alan Rusbridger had just, got a WikiLeaks story. Nick Davis had just been started or was in the middle of his phone hacking stuff, which took a while to come through. And yeah, Alan loved the law. He really liked using the law and saw the value of the law. So it was a sort of, what they call these days a perfect storm, I suppose, of things coming together at the right time. So I got there, and not long after I had been there, from memory, Nick Davis arrived with a phone hacking story. And I'd not worked. Maybe I'd worked with him once or twice, but he had a roving reporter agenda, so he wasn't in the office much. And obviously, as a story, it was very big and potentially very risky. But it was also what was great about it from my perspective is that we had to really work as a team. Not just the lawyer doing the lawyer job, but Nick and I had to develop a relationship of trust. I had to trust him in terms of what he said he'd got and that sort of thing. And he had to trust my judgment when I said I was worried about a particular way something had been written. But we were part of, once the stories got going, there was this sort of siege mentality at The Guardian. And because they were under attack, other people didn't run the story. The Murdoch News Corp team got very aggressive. So, each day you were dealing with a press release from them that you had to. So it was a much wider strategic role than I had previously sort of been engaged in. And being part of that bigger team was, again, very rewarding. And sometimes lawyers, you do work as a team quite a lot, but in a limited way. So that was fantastic, and sort of seeing that through. And you mentioned Leveson, seeing that through all the way those years later to the Leveson inquiry, and sitting through the Leveson inquiry, and thinking this really all came out because of the reporting that was done, was quite something. It's not often you get that much consequence, I suppose, coming out in that way.
And impact in so many people's lives. That exposure, yes, I agree. I think must have been incredibly stressful and exciting at the same time.
Yeah, and I mean, one thing that I do remember from that period is that and I had to stand up at the Leveson inquiry and apologise, because the Guardian had sort of gone a bit too far on some of its stories. It had suggested some phone messages had been deleted, and it turned out that wasn't the case. So, in the moment, we also had to deal with our own reporting and add corrections to things. So it was a very sort of moving process in that sense, looking at what you'd done as well. And as I say, you realise nobody's perfect.
And just sticking with you said in passing that you'd had to build this trust relationship with Nick. We've talked a lot in the podcast about trust and how important it is. Thinking about your own leadership, because you've led a team as well, and what you'd learned from that journalistic and legal team perspective, what do you think it takes to build trust like that? What's the secret sauce?
Well, I think it is about trust, and it is about respect, and it's about being willing to explain to the journalist why you think they can't say what they want to say, or why you think it's dangerous. But also, it's about trying to offer solutions and be practical about it. I mean, I grew up with a mantra that says lawyers advise, they don't decide. That's for others. So, ultimately, if the journalist really didn't like your advice, then it was up to them and the editor. And, and you would just say, and I do remember, not at The Guardian, but I do remember being called in by one editor who sort of said, "You lily-livered lawyers, you're just pathetic. You just don't want us to do anything." And you sort of go, "Well, I'm just telling you what I think about this. It's your decision. You can run with it if you want." You had to have a bit of robustness around you, in that sense. And sometimes, I remember a piece that I just got wrong. I made a bad judgment call on, and we got a complaint and had to pay out quite a lot of money over. And I realised, looking back at that I'd been talked round by the journalist when I shouldn't have been. I should have stuck to my guns. Um, you know, it's that sort of world.
I've also heard you say that you consider yourself to be effectively, if you look back at your role, like basically a risk assessor, a risk advisor. Talk us through that a little bit. I thought that was quite an interesting perspective.
Yeah, well, particularly when you're doing pre-publication work. I mean, you're looking at, is it defamatory? Is it in contempt of court? Is it breaching someone's privacy? And then, you're then saying, so if it is, what's the risk? Are they going to sue? And that's not really a legal issue at all. Ultimately, that's something that you have to let the client take the decision on. You can have a discussion about it, but you can then do what you can to the piece to lessen the risk, depending on what you think your evidence is, and those sort of things. So it's a very collaborative process. But yes, ultimately it's a risk assessment. And in most instances, although I'm sure claimant lawyers would disagree about my language, but people aren't dying about over articles that you publish. If you get things wrong, you may be harming their reputation, but it's not life and death. So the boundaries are a little different in terms of how you might assess a risk. But it's very easy to get drawn into we know he's the wrong un, he won't sue. Why can't we publish? And that is the risk assessment.
I think this is quite an interesting point, because thinking about leaders in the media, how are they to strike a balance between legal risk management, which is what you've just been talking about, and the sort of public right to know? Because I know you're quite an advocate of that, the public's right to know. So how do you balance both those things?
I think it's really difficult, and I think, ultimately, as you said, it's for the editor, or the person who's the publisher, and sometimes they have to be brave and do things where they think it is risky. I mean, the obvious example just come up again recently is the Mail and Stephen Lawrence. That front page they did, about the blokes who they were accusing of being involved in his murder. sometimes you have to do that, and you have to know that you may not be able to defend that story, but you believe it's such a big story, you're going to do it. I mean, I think also of Alan Rusbridger doing some of the ones he did, and Trafigura, the Trafigura injunction, which was sort of unknown territory. But ultimately, even though you might be advising him that he was on dodgy legal ground in terms of defences, he was willing to make a decision against the risk, and that was his decision. So that it's that sort of process, and yeah, it can be difficult. I mean, and I think some journalists would say that sometimes editors are on the wrong side. They don't publish things because they're worried about the legal risk. But again, something you and I have touched on over the years, that the legal risk is not just about being sued. It's the cost and time that it takes if you are sued to defend a case, which can be enormous.
And that strays into something I know you're also heavily involved in, and that's this whole concept of, SLAP, the strategic lawsuit against public participation, where sort of lawsuits are gaining more attention because it's more of a strategic decision rather than in the public interest or whatever. And why is that? Why do you think it's gaining more attention? Is there more of it? Is that what we're seeing?
I think maybe there is a bit more of it. I mean, certainly when you look at it from a European perspective, there's a lot, but they've always been there. I mean, there have always been, as we know from Archer and Aitken libel cases, there have been people who bought libel cases who must have known that they were not true. What they were, but they were true. What they were saying was not true. What their challenges were not true. So there are always people who try it on, try and hope that you'll cave, or that you won't be able to find the evidence to support what you said. But and McLibel all those years ago was that was a slap. Big corporation trying to silence people who are putting out pamphlets when they had enormous might and PR power behind them. And although they won on some issues at trial, and I think £10,000 damages were awarded to them, in the scheme of things, it's a sledgehammer to crack a nut. And that there's definitely an element of that, people using the law not because they really care about the outcome, but just to stop people in their tracks. And so I think following on, I mean, it came to England and Wales, particularly because of Daphne Caruana Galizia and, her murder in the car bomb. At that point, it came to light that, she was facing 40 odd libel claims, many of them, about her writing, which was mainly about what was going on in Malta. But she was facing libel claims from English law firms writing on behalf of international banks. And so, that brought that sort of concern about what was happening to a fore. And then SLAPS is an American term, as as you will guess if you don't know. I mean, no one else, only the Americans could come up with that. But it's sort of stuck and got taken up. So now we have a terminology, rather than just talking about abusive lawsuits. There's a terminology and a word that people know to use, and you look at it in terms of politicians suing, big corporations going after small NGOs who are, and yeah, it's become quite a big thing. And fortunately, here the Solicitors Regulatory Authority have sort of issued some guidance and some warning on it. And I do sort of hope that good lawyers would advise their client that they don't just resort to law for the sake of it. But you try and resolve things by other routes, particularly if there's something wrong lurking, which sometimes there is and sometimes there isn't. Sometimes there's no legal merit at all that you can determine.
I mean, what can people do, or organisations do, to navigate and challenge these really quite underhand legal tactics?
Well, I mean, there are, there's always some scope within the civil procedure rules to challenge things, to try and strike things out. But sometimes you're sort of using things that weren't designed particularly for that purpose, as opposed to generally. And so they don't always quite fit. And, if there's if you publish an article and it's got an error in it, then in theory, and it's harming someone's reputation, then in theory, someone's got a right to use the law to correct it. What you're sort of saying is, yeah, but there are other things that you might be able to do or work out without putting the full might of the law onto it. So, part of it's about trying to resolve things by other routes. And it is definitely not so much of a problem here in the sense of politicians in the way that it is in, when you see what's going on in Turkey or Hungary or Russia, or the sort of pressures that are applied there. But there are still lawsuits here that are slaps, and at the moment we've only got a tiny bit of legislation on economic crimes that legally provides a framework. So at the moment we're still sort of using, yes, the general for something that's very specific, and that also, because it's about free speech ultimately, and as you say, publishing, the right to publish, the right to know, the balancing exercise that goes on there between Article 10, Article 6, Article 8 rights is not something that's necessarily reflected in the general rules and the general process. It's a very specific thing. Um, so I think the campaigners are still very keen on trying to get some sort of slap law in this country that is, fits the purpose properly.
It strikes me listening to you, and even as far back as you doing your history and what have you, that maybe one of the reasons, and there are many, that you've been so successful is your creativity around using different elements of the law that aren't really purpose built to help the position of the paper, or what have you. Do you think that's fair? Or
I mean, it's very easy just to focus on the day job, looking at a story in terms of the law of England and Wales. I mean, one of the things that particularly happened post Snowden, post the NSA leaks and the Edward Snowden stuff, was that the Guardian and me in particular got involved in discussing the wider free speech issues. I didn't grow up knowing about Article 10 and Article 8 and Article 6. They're not something that I think were mentioned as part of my law degree back in those days. That they probably wouldn't have been at all. But you realise that, yes, there is this wider international framework of standards and rules, and you meet people who are engaged in that wider framework, and you realise that these things do apply here, and you can learn lessons from that, and by talking to people in different European countries or wherever. So yeah, definitely, and that was for me, that sort of development, that personal development of that came through what one of the side effects, the good side effects of the Edward Snowden NSA stuff, because I just went out and met people. Europeans were really concerned about privacy. The Brits weren't at all concerned about it.
that worldwide perspective, though, is kind of like a a sort of relatively new thing, is it, in terms of the legal advice? That, I'm thinking back right to the very beginning of your career. Would it been? I mean, it's more in print, and it was about UK papers. Do you think it was, or has become a more global, international role, if you like? I mean, even the footprint of the publication, if you like, is online now, isn't it? So it's a different kettle of fish.
I mean, it is a very different kettle of fish. And again, even when I was at the Beeb, most of what the Beeb did, I mean, the Beeb did get sued while I was there over a World Service story. They were sued in Uganda and Kenya from memory. But generally speaking, you were looking at UK law, people suing you in the UK over UK things. And of course, that all shifted, as you've said, with the internet, where once if you publish on the internet and someone reads it in Hungary or wherever, then you could be sued there or possibly here by them. So, all of that shifted. And I mean, that doesn't mean that I become suddenly a lawyer who knows about French law or Turkish law, because I don't. But again, going back to our discussion on risk, it affects your risk analysis in terms of how you look at those things. And also, as I say, you do start, or I started meeting people who had a wider international perspective, who knew about the International Covenant on Civil and Political Rights, which I hadn't, again, didn't know anything about, all of which have things in it and have their own case law and jurisprudence around the balance between free speech and other things, the rights and reputations of others, those sort of things. So you do start being able to, I think, see things in a slightly wider perspective.
And it's interesting. I did some homework, if you like, before we jumped on, and I was surprised to see that. I mean, I thought it was quite a low statistic, to be honest, but 53% of people worry about misinformation online, according to Reuters. I mean, I would have thought it would have been much higher. But certainly, I remember speaking with Alan Rusbridger about 2 years ago with a group, one of my forums, around what's the single source of truth that each of them had. And it was a really tricky question, in this environment we all find ourselves in. What is the source of truth that we're all relying on in terms of business or geopolitics or whatever it is? What do you think any organization can do really around combating those issues, the misinformation issue?
Media organisation perspective, particularly in the UK, most of the nationals and the regionals and a good chunk of the hyperlocals are members of a press regulator. There are different ones, Impress, Ipso, and Ipso get criticised, but there's a code of conduct there about accuracy, about privacy, about how you go about things. So, one, as a media organisation, you try to do that. You try to make sure that what you publish is accurate, and you don't get sucked in to publish first and sort out afterwards. If you can't stand it up, you don't rush into it. And I think that's been a shift. Over the years, there was that tendency just to you would just publish and pick up the pieces. Whereas I think there is a much more, and I think that the deliberate use of disinformation and the way in which misinformation spreads has made that more key. And that applies to everybody. There's a difference between fact and opinion, for starters. So making clear whether something is factual or is opinion, where people can say things that are controversial and aren't going to be true because they're value judgments. Making sure that people understand those distinctions, those basic distinctions, that this is a fact and that's a value judgment. And there's a lot of fact checking going on. There are fact checking organizations now, aren't there, out there checking the news, checking things. But people still source their information from all sorts of things, social media, where there isn't necessarily that rigor and there isn't that accountability. There isn't that, there isn't an identifiable person that you go to complain. All those sort of things. So having accountability, transparency, all of that's important. And I mean that feeds into something else we touched on, which is AI, and what that is going to do to that landscape. What is fact? What is true? People are using ChatGPT as if it was a search engine, and quite often it's got the grain of truth in it, but it's also got lots of stuff that isn't true around it. And try, a whole new generation is going to have to, particularly of lawyers. I mean, we've all heard those stories of the people searching for cases and made up cases being cited, and even I think judges and lawyers do the same thing. So there's got to be those sorts of checks and balances now, even more so in terms of trying to maintain that there are some trusted places you can go to.
And I suppose thinking about those challenges around AI, I mean, every challenge has an opportunity, right? Everyone that says that. But I think you're still heavily involved in, for example, you're on the board of the Bureau of Investigative Journalism, I know, and you're working a lot on teaching. You're at the you're doing journalism MA aspects of the MA. At what university is it? Forgive me.
City and St George's.
City and St George's.
Yep.
So you must be faced with these issues a lot in those two forums, because they're just exponentially growing, aren't they, and impacting on everything. What is the approach that you teach, I guess, on it?
Well, I think the year before last, we did sort of try to get. We had questions, scenarios to discuss, and we would put those into ChatGPT and see what ChatGPT came up with, and then get the students to look at that against what we said the sort of the real answer was, where the answers lie. So I think getting people to realize that it's not all just true, and you have to go away and then double check it, for starters. On the other hand, I think people find it really interesting as a writing tool, because it does come up with, if you're looking for, I need to say deepest sympathy because X has died. ChatGPT can come up with all sorts of fantastic things. I need to write a eulogy about someone who was whatever, so it's got enormous potential. But I think there are legal concerns around copyright. There are legal concerns around, hallucinations, as they call them, untruths. There's a case that I read about over the weekend about someone in Norway who ChatGPT is accused of murdering his sons or something. And I mean, that throws up all sorts of issues. It's not true. Whose liability is it? How can you sue ChatGPT? We know, if it's an American-based West Coast company, very hard to sue them and get them to accept jurisdiction. And whose fault is it? ChatGPT is just gathering up unspecified information and aggregating it in some way. So all sorts of challenges. I think certainly in the media field around what's it going to do to journalists who are employed. It's going to take some work away. Is it a decent resource for them to use? I mean, the Guardian's I think got a whole sort of series of guidelines around how it's going to use it. It again is trying to be transparent when it uses it or when it doesn't use it, for things that people can see and people can't see behind the scenes. So again, we're still everybody's feeling their way, aren't they, at the moment?
Yeah, it's exciting at the same time, I think, and it was very interesting. There's another podcast I'm going to release, and Klaus Moosmeyer from Novartis, he's a chief ethics and compliance officer there, speaks about how we might be judged on this 3 years from now if we're not dealing with it in the now, if you like. I think it's really interesting, because even looking beyond the legal landscape, how do leaders across all the industries that will be listening to this podcast navigate the ethical dilemmas that AI are likely to throw up,
Yeah, I mean, on the other hand, I heard someone, I think from Mishkon's, talking about how, they're building or have built a bespoke sort of contract type, so in terms of doing some basic stuff, putting together a contract for X or Y, you build your tailored thing and it can produce it. And you don't need to start from scratch and add paragraphs 3, 4, and 5 to this for this, because it can do all of that. So, in terms of sort of productivity, and you would think cost and charges to clients, that sounds like it's probably quite a good thing. But I worry then about how young lawyers learn about drafting skills, about, why a particular clause might be dangerous because it's just been put, I mean, there are all sorts of things, of consequences about how you use it, where you use it, what you say about what you've used.
Well, Just thinking around those young journalists coming through the system and the lawyers for them, more to the point. You've
Yeah,
co-authored McNay's Essential Law for Journalists. I think it's in its 27th edition. So it's obviously kind of a fast-paced. Um,
but not all by me.
no. I think you co-authored. I did with Sean Harrison, I believe.
That's right. Yeah.
So what do you think, or what do you hope the next generation of journalists take away from that resource, given all the things that we've just talked about?
I think what you want them to take away from it is that they can't avoid the law. They can't publish in a vacuum these days. And they just need to. Again, it's got much more complicated. The landscape. I mean, we did, very early on we talked about the fact that there wasn't really a media law. I mean, when I started, you looked at defamation, contempt, copyright. Privacy didn't really exist. Data protection was, not even in anyone's minds, particularly. And that landscape's developed and grown along with a whole load of other things. So, journalists definitely need to just be aware that there are consequences to what you publish, and also to how you gather your evidence. Again, we touched on Leveson and phone hacking, and there are ways in which you can gather information and ways in which you shouldn't gather information. And so, I think part of the purpose of the book is and always has been to make them aware of that, but also to give them like sufficient knowledge, particularly around the court reporting regime. There's enough in McNay's for a young journalist to be able to go into court and say, I think you've got this wrong. I think I should be allowed to report this. And hopefully, and over the years, it's definitely been the case. Certainly, that journalists have gone into court and waved McNay's and said, I'm going to read you what it says. You can't make this restriction, or you should let me in, or I should be able to report on this. So, that aspect of it is still there and is still good. But just making them go, oh, there's a law that says I can't do that, or I shouldn't do it, or I might need to think about how I do it. In a way, the thing about McNay's has always been that it tries to be practical and accessible.
So I think one of the things that I really wanted to ask you, given that you've been through so many of these major journalistic pieces of advice, really, that you've had to give over the years, is what the qualities you think are of a truly courageous leader in such a challenging legal and media environment.
I mean, that's a really difficult, it's a really difficult question. I mean, from my own perspective, what I realized I could bring to the party was a calmness, an assessment of risk. So not saying you can't do it, you mustn't do it, but if you do it, this might be the consequences, as part of a bigger strategic discussion. And yeah, also recognizing that these stories, these big stories, that they're vastly collaborative. The WikiLeaks stories, the NSA stories. It wasn't just the Guardian, although the Guardian was one of the leaders. There were journalists and lawyers all around the world doing it, and you might not all agree on the way forward. So I think you have to sort of look at what your job is, what your role is, and stick with it in that sense.
And if you had to look back at your career, although it's still moving forward, as I know it will for many years, Gill, what's the moment that you're most proud of, do you think?
I mean, I tell you, the moment I still most enjoyed, although in the moment it was quite terrifying, was just was going to Hong Kong on the Snowden stuff, when Snowden was in Hong Kong, and the whole thing just blew up. And you're there as a lawyer. Lawyers are there sitting at desks with quill pens, writing things, and I'm walking round some park with a journalist with no electronic devices telling me what's been going on. And so, in terms of sort of career exciting moments, when I started at Coward Chance, I definitely remember them saying, have your passport in your pocket. You never know where you're going to go. And I never went anywhere with them. I might have gone to Bristol or Manchester or Birmingham, but once I got into the media, I did start doing traveling and having this sort of wider perspective that I never really thought, it just happened in that way. So that's, and seeing the Guardian through phone hacking stories, the NSA stuff, when, you've got the government threatening you and the government coming in and angle grinding down computer databases and things, all of that, you've got to look back on as thinking I was part of it. It wasn't me by any means, but I was part of that process.
Yeah, and it was your counsel that enabled that risk to be taken, right? Because it was a managed risk.
Yeah, managed risk. Yeah, I would agree. Yeah.
Wonderful. And I've got one last question before we part ways that I ask all my guests. If you were to create a leader's survival kit, what items would you include in it and why?
Well, you did tip me off about this. I sort of thought, oh God, I don't know what I'd say. I know if it was me, I'd give you a list of 5 items: coffee, chocolate, gin and tonic, my bike, and my iPad. Those are the 5 items I would have. But that's not what your question was. So then I sort of thought, okay, what would I say? I would, in however it can be manifested, whether physically or virtually, time away and downtime, your own headspace. I would definitely have that in whatever way it can be done as part of my essential items. I would also include in that what we've discussed, knowing yourself. I would have that as a thing, because I think if you know how you operate, it's not just Myers-Briggs, but that sort of analysis, how you react to other people, how they will react to you, how you're so some sort of personality thing that you've dealt with and about you and how you fit. And then I would add into that a luxury item of comfort, which can be a physical item. And I did think, again, going back to a previous discussion, whether that's Blunston boots, which is for me, or Jimmy Choo shoes for others, a luxury comfort item that you feel relaxed and confident in.
Oh my gosh, that's an amazing one. I think that's my favourite we've heard so far. Thank you so much for your time, Gill. It was absolutely gold. Thank you.
Pleasure.
That's it for today's episode of Insights from the Coalface, Elevating Leadership Beyond the Boardroom. I hope this conversation left you with fresh insights, new perspectives, and a deeper connection to the challenges and opportunities of leadership. If you found value in today's discussion, I'd love for you to share it with your network, leave a review, or reach out to me with your thoughts. Leadership can be a lonely road, but it doesn't have to be. Let's keep learning, growing, and supporting each other. Until next time, stay resilient, stay authentic, and keep leading with purpose.